My name is Kathy Abbass, and I'm the director of the Rhode Island Marine Archaeology Project, the sponsor of this event this evening. So thank you very much for coming. And what we're going to do is have our speakers each speak for 15 minutes each on the various assigned topics that are in your agenda that you see there. And then we'll have a general discussion with the people who are in the panel. If there are questions, there might be an opportunity for that. At the end, the last comment is mine. As the moderator, I get the last word. Those of you who've worked with me know how important that is. And then we'll be able to say we've learned something about legal processes and shipwreck protection.
Thank you all for joining us tonight. This is one of Rhode Island's 5 old state houses. They couldn't decide for the first 150 years where the capital should be, so 5 different towns took turns. And this didn't get to be the actual State House until after the Revolutionary War. So it is now the Historical Preservation and Heritage Commission, the state office for the protection and regulation of the significant historical resources of Rhode Island. So one of those resources is, of course, our shipwrecks. And so it's a pleasure to welcome Kathy Abbass and the Lusitania and the Endeavour here tonight.
What I do want to talk about is some of the legal issues really that come into play whenever we've got a shipwreck that people are interested in. And I want to talk about how the courts have dealt with people's efforts to try and access and preserve and recover artifacts from shipwrecks. And so with that, I think in an effort to try and be brief, I'm going to just touch on 4 concepts that I think are relevant to what you're going to hear about tonight from John and Gregg. And those are the concepts of salvage, law of fines, the Abandoned Shipwreck Act, which is a federal statute, and the Rhode Island Antiquities Act, which is a Rhode Island state statute dealing with certain abandoned shipwrecks. Now, I'll start by talking about salvage and fines together. They seem to go hand in hand. Many of you have probably heard of the concept of salvage. The concept of salvage really is there to address a person's efforts to try and recover and save property at sea when it's in danger. And it's a concept that's there to try and actually entice people to go about and undertake those efforts. And then the law of fines really deals with how ownership of otherwise unowned property is addressed, and that's dealt with through the courts. And so the questions really are, like I said, what are the laws of salvage and fines? When do they apply? And really, why does it matter? There are, in essence, 3 issues that really come into play when courts are figuring out whether or not a person's efforts really constitute salvage. And so number 1, as I mentioned, the property has got to be considered to be in peril. That's a tagline that you see oftentimes in the court decisions talking about this. Secondly, the person who undertakes the act of going out to try and rescue either the ship or its goods has got to be acting voluntarily, meaning they weren't under some other obligation to go out and try and rescue the stuff, whether it be through a contract or, because they actually caused the harm that actually put the ship in danger. So it's got to be a voluntary act, and the person who does it has got to be successful. So that means that a good attempt isn't enough, because at the end of the day, what you get through salvage is a reward. The courts refer to it as a reward. And again, the reason why they look at salvage as an opportunity to provide a reward to somebody is because the concept is that we want to promote people to go out and undertake these dangerous activities, to go and save these ships and their cargo. And so that way you can take the stuff and put it back in the stream of commerce. So if a ship goes down, that's not good for anybody. If cargo goes down and sinks and is lost at sea, that's not good for anybody. And the idea is that were it not for the salvers' actions, all that is going to be gone, and then as a result, the court is going to give that person a pretty handsome reward. So, the general rule in the salvage context is a person who has gone out and undertaken a successful salvage recovery operation. The rule of thumb is about a third of the value of whatever they save. So that can be pretty significant. Now, those percentages will go up and down depending on what level of danger the ship is in, or however valuable the property may be, however difficult the salvage operation was. So to give you an idea of sort of where and how large these salvage awards can be, one of them was actually for just over $4 million for a company down in Texas who had actually managed to salvage one of the external fuel tanks from a space shuttle. So, as you can imagine, that's a pretty valuable piece of equipment. So the court was, in that situation, willing to offer or give the person over $4 million. I personally had been involved in one case where my client I think we ended up with an excellent result because we only had to pay $25,000 for a 100-yard tow. That's to give you an idea of how large these salvage awards can be. So secondly, again, this concept of fines. Again, it was an idea that really initially developed at law to go with the idea that this is, if something is truly not owned and you are able to reduce it to possession, you can bring it to court, have a court bless it and say, yes, you own this thing that you found. So again, the distinction for these two concepts, particularly as they relate to shipwreck efforts, is the difference in the outcome. So remember, salvage, the person who undertakes a salvage effort only gets a reward. They do not get ownership of the item. It's presumed that the item is already owned by someone else. That's how it really differs from the idea of fines. So in the shipwreck context, as you can imagine, there are several, in many cases, that talk about a lot of these issues, and there are different ripe areas for legal battles when you're dealing with shipwrecks. And here's I've highlighted at least four that I think are particularly important, and again relate to, I think, what you're going to hear about today. So first off, this concept of peril. Remember, salvage is there to try and promote people and incentivize people to go out and save property that's in peril, at risk of loss. So there's been a lot of discussion as to whether or not you can even logically apply this concept of salvage to a shipwreck. The wreck has already been at the bottom of the ocean for hundreds of years, if not longer. How much peril can it really be in? That's really gone by the wayside now. I think at this point it's generally accepted that a historic shipwreck is deemed to be in peril because it's at risk of being lost to the environment. So in theory, if a person goes down there and is able to go and access the wreck, they are, in fact, accessing property in a wreck site that is in peril of being lost. Really, I think that the more interesting, a very interesting issue, and one that gets a lot of attention in the courts, is whether and when a shipwreck is deemed to be abandoned. So there are some courts that take the position that a ship can never be considered to be abandoned unless the owner has actually affirmatively gone out and said, I hereby abandon my ship. Who does that? Nobody does that. So other courts have taken a more liberal approach to that and said that with the passage of time, it's absurd to think that an owner of a wreck that went down 300 years ago, or his or her successors in interest, or heirs, or children, or insurance companies actually still intend to maintain ownership of a wreck that was lost hundreds, if not thousands, of years ago. So in that situation, courts have been, some courts have been more willing than others to imply that a ship has been abandoned, and therefore apply the concept of fines and award ownership rather than apply the concept of salvage and just award a reward for whatever you might recover. And I think this wraps into what one of the points that I think Gregg is going to be talking about later today is, in particular, how do courts deal with this idea that technology continues to evolve. And over time, wrecks have become more accessible than they were in the past. And based on that idea, courts have also said that, look, the fact that an owner of a wreck, or it's the insurance company who actually paid out and then assumes ownership of it, the fact that they haven't actually gone out and done anything to try and access the wreck for a 100-year period, that didn't matter, because in reality, there was no technology that would have allowed them to do it. So the courts then, in that situation, had been willing to sort of start the time to figure out whether or not they've actually abandoned it, just sort of implicitly, based on when that technology became available, which in that situation, the court said it was about the 1980s, when they were actually theoretically or technologically able to even access it anyway, so they weren't willing to ding them for the 100 years before that they didn't. Another issue that comes up again in the salvage context is this idea of success. Keep in mind again that the purpose of salvage is to return goods back to the stream of commerce, and I think it raises an interesting question as to whether or not an archaeologist's efforts in that regard could actually qualify as salvage. When if theoretically the archaeologist's mission is to try and preserve the asset, not actually recover certain items, not return them to the stream of commerce, but instead leave them there for future study and exploration. So I think that's another area that you're likely to see come up in some of these shipwreck cases. And the last thing that I think is worth talking about here is this concept of first salvo rights. This is another battle that comes up oftentimes in the shipwreck context. There's this idea of first salvo rights, which is a situation where the court will, in essence, allow or enter an order prohibiting other parties from coming in to try and take over a salvage operation that's underway. And again, the idea is that these salvage operations can be expensive, they can be dangerous, and what they don't want to have is a situation where a salver comes in and is starting in on a project, and only to have other people come in and start picking away what would ultimately be the goods that are going to be salvaged, and really reduce what they could actually get from the reward. A way that this does come up, in fact, in these historic shipwreck sites, is it raises the question of whether or the extent to which an archaeologist may have to actually be undertaking the study in order to have the Salvage Act, if you will, be considered to be ongoing and successful. Right? So if an archaeologist isn't going down to the site every day and pulling up a bar of gold every day, that's the traditional way that you might hear about or think about this idea of first salvage rights, because you're a true salver. You're going down there. I'm getting the bell from the ship. I'm getting gold bars, and it's a long process. I go out there every week to go and do it. In that case, yeah, that's easy. That's clearly you're the first salver. A court, I don't think, would have any trouble saying, yes, you're the first salver. You've got special rights. Nobody else can go in and interfere with you. It's a different question, though. When you've got an archaeologist who's really, my job is done here. I'm going to go down maybe once every other year just to take a look at the site and see how it's holding up. All right, last two concepts, again, I think they work together. I can cover them quickly. Dealing with shipwrecks located in Rhode Island waters. Under the Abandoned Shipwreck Act, that's, as I mentioned, a federal statute that said that the United States will take title to shipwrecks that are abandoned and have been embedded in the submerged lands of any state. Any ships or wreck sites that fall within those categories, the United States automatically takes title to them and then simultaneously transfers them over to the state to regulate. The Rhode Island Antiquities Act essentially works as a counterpart to that. Under the Antiquities Act, Rhode Island said, yes, thank you very much, we'll take your shipwrecks. The state takes title to them and has said that it will take title to anything that it's considered to be underwater historic properties, which it describes as anything that's been unclaimed in Rhode Island for 10 years or more. And once that shipwreck or the site has been acquired through the Antiquities Act, then the state is able at that point to regulate investigations, the dive sites to the trip, and to limit any otherwise salvage activities of historic shipwrecks in Rhode Island waters. And I think a lot of these concepts really come into play here with what you're going to be hearing about with the monitor efforts, with the Lusitania, and with the shipwrecks that are left over in Rhode Island. I think they raise really, really interesting legal issues, and they really present the conflicts between, an owner of a wreck site and a person's ability to go out and do what they can to try and, salvage it and save it and return items to the stream of commerce, while at the same time accommodating the public's interest in archaeology and continuing to study these sites.
Well, I thought I'd start out by just seeing if I could say a few things about why we should protect shipwrecks. Why are they important, and why should we put all this effort and fuss into shipwrecks? And I'd say, just in general terms, any comprehensive history of the United States must surely include the vast and intricate maritime network that was an inseparable aspect of European settlement in the New World. It's an inescapable fact that ships and seafaring played a basic role in America's development, especially along the East Coast, where our rivers and bays and tributaries comprise an expansive network of waterways that encouraged and augmented rapid and widely dispersed settlement, provided transport for communication and commerce, and strongly influenced the very character of these European settlements. Therefore, one might assume that the shipwrecks that can tell us about our maritime heritage are important links to our past and would be automatically protected along with all our other legislation. But as I'm going to try to convince you in a minute, that hasn't been the case. But why are ships important anyway? Why should we worry about all this? One of the areas that shipwrecks contribute to a lot is the extremely good organic preservation that we get on shipwrecks that doesn't often occur on land. Ship sinks in nice soft sediments, and it settles down into that mud, and it's covered over, and the organic materials, sometimes metals too, but generally the organic preservation is the thing that makes shipwrecks more unique, because terrestrial sites, you get metals, you got other materials, but organics, not so common. And a lot of shipwrecks have yielded artifacts and hull remains that have shed new light on naval and merchant ship technology. But even more importantly, I think we've gotten some really fascinating glimpses into what it was like to live aboard these ships, the life these sailors and explorers experienced on board ships during the age of sail and even more recently. Even prehistoric structures sometimes survive underwater. House pilings, fish weirs, canoes, even paddles, and fishing and hunting implements. For instance, a good example is the Crannog sites in Europe, that you have existing surviving wooden pilings of these waterfront properties are developments that go back 5 millennia, and archaeologists still find them on a fairly regular basis. But I want to concentrate on the shipwrecks for this evening and give you an example. The Mary Rose, a warship that sank near Portsmouth, England in 1545. Archaeologists excavated scores of bows and thousands of arrows, along with lots of other organic materials, including human remains, some of whom were still wearing clothing that allowed them to identify the occupations of these men aboard ship. So you get this organic preservation that really has contributed to terrestrial archaeology and the overall interpretation of the past. Another thing shipwrecks do is provide a snapshot of the past, since when they sink, the material that's on board, if you have the date of the sinking, then you know that all of those artifacts are things that existed at that particular point in time. We call it the snapshot or the time capsule effect. And that, in turn, has helped other sites. A good example that I'm familiar with is there was an early site, not Jamestown, but a site that dates back to the same time almost as Jamestown. It was excavated by Ira Noel Hume at Colonial Williamsburg. And in order to date the site, he actually went to a shipwreck in Bermuda, the Sea Venture, that was on its way over to the colonies. And by looking at the artifacts that were on the Sea Venture, he knew the date of the sinking of the ship, and he was able to prove that this site was as early as he thought it was. So, again, there's a really strong tie-in with what shipwrecks can teach us. Another one is the Vasa, the Swedish warship that sank in Stockholm Harbor in 1620. It was raised and tacked. It actually was floated into a dry dock on its own heel after all that time, and was preserved, and it's got a new museum that's it's not new anymore, it's 20 years old or so now, but the Vasa is an incredible site. Tourists who come there and to the Mary Rose, you can stand around and listen to the comments. People are absolutely in awe because they're huge and they're beautiful, and they're some of the most magnificent examples we have of the past. And the Vasa is now the largest tourist attraction in all of Scandinavia. So we're talking economic benefits of shipwrecks as well as all the other advantages that they bring. And so just think what we would have lost if these had been salvaged by treasure hunters, the hulls pulled apart just so they could get to the contents inside. And in this case, they would have been disappointed because there wasn't any treasure. But we've seen relatively intact Spanish galleons literally dynamited in the 60s down in the Florida Keys because they thought there was treasure there, and as often as not, they didn't find anything. And meanwhile, we've lost an irreparable damage has been done to these hulls. But there's a different kind of controversy that it doesn't directly relate to the legal aspects, that you'd think that after a half century of these underwater projects where we've excavated ships, we've produced results like Mary Rose and Vasa and a number of other sites, that underwater sites would be considered as important as terrestrial sites and what they can teach us about our past. But that really isn't the case, even after all this time. For instance, the Antiquities Act, which you would think would have been the first thing that you would have mentioned as a way to protect shipwrecks, because it's the backbone of our antiquities legislation in America, specifically includes anything underwater. Why would that be? I can't tell you. So why does this double standard in archaeology still exist? It's true, some people argue, well, underwater archaeology, you use all this dive gear and bubbles come up and all this stuff, but other types of archaeology have specialties as well. People rappel down sides of rock faces to get into Paleolithic caves, and they have to know how to rock climb and do all those things, so that doesn't fly. One of the things is that the dichotomy seems to have emerged from the fact that for at least 2 millennia, there have been different laws regulating things that happen at sea versus on land, and some of the things that you mentioned. We know that a couple of thousand years ago, the island of Rhodes actually developed kind of the law of salvage, and it was actually to reward people for saving life and property in times of ships in peril. The other thing that really has bothered me all these years, there's another less tangible factor that affects shipwreck preservation, especially in the States. That's for some reason, Americans tend to believe that shipwrecks and other underwater resources should be the property of the finder. And this finder's keeper's attitude is really widespread. For instance, no one would really think about chipping a souvenir stone from our Capitol building in Washington. But many, many people, I hear it all the time, they believe it is their God-given right to dive on a U.S. warship that happens to be on the bottom of the ocean and rip it apart, even though there might even be human remains of our fallen sailors still on board. I don't get it. But more positively, in recent years, a lot of countries have recognized that their maritime heritage is important and it's being destroyed by the salvage process, and they've begun to pass protective legislation. I'm not going to go into that, but I want to point out a couple of things that are really key for archaeologists today, and that's that we now are getting into a period of more enlightened legislation. We have some new federal legislation, the Abandonment, Shipwrecks Act, and others that help protect these ships. And we have an international convention, and many states have also either added or upgraded their legislation. Probably the best thing that's happened to underwater archaeology is the UNESCO Convention on the Protection of the Underwater Cultural Heritage. And that was enacted in 2001, and dozens of nation states have now signed on to this. But sadly, a lot of the industrialized nations that have the money to send salvors out and destroy these sites haven't signed it and aren't likely to sign it anytime soon. So that's kind of a drawback. But the good news on that is that a lot of our federal and state agencies and our societies for professional archaeologists have said, well, even though the U.S. hasn't signed on to this convention, we think it's the right way to go. We think that the way it's worded, it gives best practices for archaeology, and that we feel like we can at least say that we're going to adhere to these, whether it's a matter of law. For us, it's a matter of principle and practice. And so we've seen some new advances there. And so the UNESCO Convention really gives us a new global framework for re-examining and revisiting our legislation both at the federal and state level, and looking to follow this UNESCO example and hopefully improve protection of wrecks. I'm going to jump real quick to something I just added in today because of the specific instance we have with the Lusitania. I got to thinking, Gregg and I are both on a naval panel for forensics that deals with shipwrecks. We all get to see all the CSI stuff on TV. Well, there are a bunch of us who actually try to do CSI stuff with shipwrecks, and it's a lot of fun. It's very educational. And I find that I got to thinking, what's the difference in the forensics we do at the Marine Society and what I do as an archaeologist? We both have the same goal, really, and that's to find the truth about past human actions and events and even motives. One is for crime, another one is for science and knowledge. We both use the same methods. We prefer non-destructive testing, retention of the samples that have been collected, and where necessary, though, we do destructive testing when the ends justify the means. So again, we kind of are doing the same thing. So it's all about deductive reasoning based on the available verifiable data. And the skill is in getting the data and analyzing it in such a manner that we get valid results. Because there's a lot of bogus history out there and bogus archaeological results. So we develop conclusions, we determine sequences of events that took place in the past and who was involved and why it happened. And so at this point, I've got to give you a major admission. It shouldn't be an admission, but some of you may not know that we admit to this. Archaeology is a destructive process. The nature of archaeology is you destroy the site. That's what you do. You have to dig it up in order to get the information. So, well, that's terrible, isn't it? Well, no, not if you do it right. And that's where it really comes down to the quality of the personnel and the experience of the personnel doing the excavation. And that's why we go to school for years and years to try to learn how to extract the information and not ever lose the site. The site never goes away if we dig it and interpret it and document it properly. The site is not the end goal. The information, the knowledge about our past is the main goal. So a shipwreck I excavated in Yorktown, it was a Revolutionary War ship, very early and important shipwreck. But in order to learn enough about it to really make positive decisions and conclusions, we had to disassemble it. We took every piece of it apart that we could. And that's the right way to do it. If you look at ships like La Belle off the coast of Texas that was recovered by archaeologists a few years back, it was completely disassembled. Every piece was studied individually. It was put through a conservation process at Texas A&M University, and it's now it's been reassembled and put on exhibit with a beautiful book describing the whole process. But the ship is now in Austin at the State Museum there. And so it's really the results that we're looking for. And there are always more than one way to skin a cat, and there are always circumstances on a site-by-site basis that may dictate different methodology and even destructive testing in order to get the results. So I can't stress enough that one of our problems as archaeologists is that we often have to rely on bureaucrats to give us our authority to do things, where the bureaucrats really don't understand what we do and how we do it and why we do it. And I think this relates to some of the issues that Gregg's been facing, so I won't delve into that anymore. I'll leave that for him. So I just want to finish by saying that I've been involved in shipwreck protection and management now for over 40 years. Can't believe that. And I've seen a lot of big improvements, so I don't want to end on a negative note, because there has been advancement in legislation, and I think even in the attitude of the stakeholders. Who are the stakeholders? Well, sport divers, some of the deep divers now, the so-called technical divers that are venturing down to wrecks that are 3 and 4 and 500 and 600 feet deep that used to be safe just because they were deep, but now they're available to these deep divers. But they're starting to find out that maybe we're overstepping our bounds, even though we can get here and nobody would know how much damage we're doing. Maybe we should rethink the way we work. And I have to say, and I'm going to get in a lot of trouble for this, even the commercial salvers have changed a lot. It used to be, as I say, and it's no secret that dynamite was routinely used on a number of shipwrecks to get to the treasure. But salvers now, even if they do want to sell the material and make a profit to pay for all their work at sea, they still often employ archaeologists now in their work. They often have a really good conservation lab, well funded, and they often publish their results and put things in museums. So I think we've seen a lot of good progress. So I'll just finish by saying that it's my hope that in the very near future, we won't really need sessions like this, because it will all be resolved and everyone will be on the same page that archaeology does contribute to an enriched life for those of us who are living now. We learn more about the past. We learn to respect those people who were every bit as bright as us and had less technology to work with, but still did some amazing things. And archaeology, both on land and underwater, is how we learn more about those people. And so I'll finish with that, and I certainly hope that all of you will join us in trying to convince our elected officials of the importance to continue to support the preservation and management of our cultural heritage. Thank you.
Kathy took the bull by the horns and put this together. She's an amazing lady, and I'm indebted to her for doing so. I didn't think this would ever happen, where we'd have an audience that actually gathered to hear some of the tribulations that we go through in the salvage business. And having said that, I want to point out that I've been working on this for only about 48 years, so to try to handle it all in 15 minutes is not going to be easy. I also want to emphasize something now, and I'll come back to this, and that is the importance of the proper use of and meaning of words. I think we sometimes overuse or misuse words, and that gets us into trouble, and I'll come back to that. To begin with, in that very respect, Kathy called this by title, Property versus Preservation. I tried to convince her without luck that it really should be property rights versus preservation in situ. Preservation in situ is the mantra of the archaeology profession, and that's fine for stuff that's on land. I can understand the concept, but stuff that's at 300 feet or 400 feet below the surface of the water, to talk about that as preservation in situ is just an extreme misuse of words, I think. I call it an oxymoron. And the problem with just calling this property, this session about property, it doesn't talk about property rights. And to me, that's a very important part of the title, it should be. And I want to comment on Mike's presentation. Salvage, whether by accident or on purpose, well designed, is extremely honorable activity. I think most of the people in the world get the idea that salvage is something that nasty people do, like pirates. Actually, that's not true. Salvage is a very beneficial thing, and it's an honorable thing, and we need more useful salvage and less just throwing stuff away and forgetting about it. I want to further add that there's about 300 or 400 years of admiralty law that covers this field. Mike handled it very well. I had my first exposure when I sued the Queen of England because she tried to take my property away from me. I guess you've got the handout, which we passed out, which I've been in 3 courts here in the United States, in Britain, and in Ireland. Each time I've won, I got this ownership through the simple process of buying the title from the insurance company that took it over and paid off Cunard. So there's nothing fishy about it. There's nothing strange. It's very straightforward. It's business. And I think the fact that admiralty courts have a set of 300 or 400 years of law, which people seem to want to ignore, is very unfortunate, because I think the law is very good in this matter. I think it's very clear. Now, in that respect, ownership, I want to step one aside, a little side trip here, and say that there's an incredible economist in the world today. His name is Hernando de Soto. He's Peruvian. He's written a book called The Mystery of Capital. He talks about property rights, and the points he's making about property rights is that without property rights, we would have no economic benefit in this world. He points out that there's over $1 trillion of assets in the undeveloped countries in the world that have no value. They're what he calls dead assets, because they're of no use to anybody. You can't borrow money against them, you can't use them, you can't buy them, you can't sell them. Those are countries that have no legal setup, no organized recognition of ownership. They're worthless. And I think it's very important that we in this country and in the Western world that have benefited so much from the establishment of a legal process of ownership, that we support that concept in every respect. And that's one of the reasons why I get so incensed when my ownership is ignored completely by Ireland in my efforts to try to do what I think is the right thing for the rest of the world, for Ireland, its citizens, and so forth. So I recommend that book to you. It's an extraordinary book. It's not easy reading. It's not a short one, because like all economists, he talks too much. I guess I majored in economy. Maybe I talk too much, right? But I think it's worth reading. I want to put my work on the Lusitania in perspective in this way. When the Pan American flight was blown up out of the sky over Lockerbie, we spent over $10 million. That's just my guess, but I think it was probably well over $10 million in picking up every piece of that. And this is the government, and putting it all together to try to determine who it was. As we now know, it was a Libyan that caused that, took out an attaché case with a bomb on it, put it on the plane. And in the case of TWA 800, which was blown out of the water out over Long Island, as you remember, about 10 years ago, we spent about $20 million getting every piece of that off the bottom of the ocean and reassembling it in a hangar and examining it to try to find out exactly what happened and how it came about. I believe it was proven pretty well, though it's never been admitted, that it was blown out of the air with a surface-to-air missile. But we spent $20 million on it. And now, with the Malaysian airliner that went down in the, I guess, Indian Ocean or the Pacific Ocean, we don't really know where it went down, We've already spent about $100 million looking for it. Why is this important? We haven't spent $1 of public money, as in these other cases, on the Lusitania. Now, each of those 3 airline disasters, just to name a few disasters, had about 300 people on them. That's 300 people that died. Not very nice. Obviously, in the case of the Lusitania, 1,200 people died. It was the same kind of atrocity. In effect, they were blown out of the water, and yet we've never spent a nickel trying to figure out what was the cause of that, who was involved, and why. And I think that's extremely disproportionate, and I'm trying to do this with my efforts and getting other people involved, and I get no support whatsoever from Ireland. And this is a little bit of a problem for me. I think it's not quite fair. I'm blocked every inch of the way by, believe it or not, by 2 bureaucrats who happen to have archaeology degrees, and they seem to have the ability to stop me in my tracks when I'm spending my money or the money of people that I come to and ask for help for, to find out what was the cause of the disaster that took place in 1915. I have 3 basic missions. One is the recovery of artifacts, and the reason for that is because I think we have a wonderful museum that's being built. It's in process right now on the old head of Kinsale. It's a marvelous site. It's about 150, 200 feet up in the air. It looks out over the ocean where you can see the Lusitania out where it used to be, out on sea, 11 3/4 miles offshore. It's an incredible location. There's an old Napoleonic watchtower there that's been restored. There's a memorial garden there. It's a beautiful garden, and the museum is now under construction. And we want to fill it with artifacts from the ocean, from the Lusitania, to help support the memorialization of this act where 1,201 people died. Incidentally, 1,201, where's that come from? There were 1,198 people. That's the usual number of deaths for the Lusitania. But those people that say 1198 refuse to recognize the fact there were 3 German stowaways on board the ship, whose names, of course, were not involved. They were human beings too, so I say there were 1,201 deaths. I think it's a little bit more accurate. My second research mission is into the second explosion. The ship was not sunk by just 1 torpedo. Ordinarily, it would take 2 or 3 torpedoes to sink a ship that's 800 feet long, 790 feet long, and it wouldn't take 18 minutes. It was the second explosion that sank the ship in 18 minutes, an incredible sinking. If you try to scuttle a ship that size with the professionals doing it, it would probably take you 2 to 3 hours to do so. And so you have to say, what was that second explosion? What caused it? Because that's the essence of history. And that's what's most important here, is what is really took place. The third mission I have is the true history of the actual event from beginning to end. And in my opinion, the only way we'll solve that is if we're somehow able to find the captain's safe. Every ship that left New York to go to England the skipper had special secret sailing orders. Secret sailing orders. Captain Turner was an incredibly capable captain. He had done an enormously good job for years for the Cunard line. He wasn't where he was by accident. It was on purpose, and it was based on his special orders. He's been accused of having not followed general orders, which was to approach England or the south of Ireland with a zigzag course to try to make it difficult for submarines. He was on a straight course. The reason was because his special orders must have told him that. He wasn't 60 miles offshore, he was 14 miles offshore at the time this struck. Another thing is, if any of you are ocean going, you know how difficult it is to find a specific spot. We're talking about 1915. They didn't have GPS. They had instruments that looked up at the moon and the stars and took measurements, and they took sightings. For that submarine to be where it was, and for that ship to be where it was, each of them having one 2 weeks been at sea, the other a week at sea, to be at the exact perfect spot for that submarine to get the exact perfect shot from 700 yards away, 700 meters away, and that was as far as you could be away from a ship and still have an effective torpedo shot, is just so incredible you have to say it couldn't have been by accident. It had to have been set up. And the only way you'd know is if you find the captain's safe, find his orders, and save them, as can be done now with some of our new technologies, and actually find out whether the captain was doing exactly what he was told, was exactly where he was supposed to be, and of course the submarine knew the same thing because the submarine captain had been informed from the Ministry of theirs. So this is my missions, and if these missions are not appropriate, fine, but if they're appropriate, why do the bureaucrats get in my way and prevent me from doing this? Definitions. History and archaeology are not the same. History is everything that happened yesterday or before. Archaeology, the dictionaries, the three dictionaries that I've been to, Webster's, Oxford, and so forth, all say the same thing. Some of them with slightly different words, but they all say archaeology is the scientific examination of ancient peoples and cultures. The scientific investigation of ancient peoples and customs. The Lusitania is not ancient, and it's not peoples and cultures. So to call the Lusitania an archaeological site is obviously a power play by someone. It's not because of what it is. I keep telling people, and the problem we have is that the judge in the Irish court, when he rendered his position, he was a good legal scholar, and he said, yes, Gregg Bemis owns it, and as he put it, we must be very careful to be respectful of Mr. Bemis's property rights. But he called it an historic and archaeological site, and the archaeologists have hung their hat on that, and they won't let me touch it without permission, and I've had to go to court now 3 times over there to try to get through this. It's an example of the misuse of words. I put it this way: you can call a horse a pig, but you can't make the horse go oink. So this is not an archaeological object. It's a historic object. I agree it's historic. I agree it should be respected, but I also feel that my missions are an appropriate missions and I should be allowed to pursue them. I think there's something very strange about the archaeological profession that for 20 years has blocked every effort of mine to the fullest extent of their ability to achieve the 3 missions I've mentioned above, which are for the benefit of the Irish citizens and the benefit of the world, or the benefit of history. It makes no sense to me. And I feel that I am being brutalized on my property rights as an owner, and I can't emphasize that enough. Ownership rights are terribly important. They're what's made the Western world as advanced and as economically successful as we have been. Western Europe, over here, North America, I think is a great mistake. I would like to hope that this meeting and panel discussion would be the beginning of a discussion and an opportunity for owners such as me to do more of this kind of work, not less of it. I have great respect for the archaeologists, particularly the ones here, of course, who are working so hard on the Endeavour. And I'm not an archaeologist, but my heart is in the same place. I want to find out what happened, and I think I should be allowed to do that. And I'll look forward to the question and answer session later on, and thank you very much.
I'm sorry I can't be with you for today's discussion on the preservation efforts of the Lusitania and the Endeavour, 2 remarkable vessels that play a part in our state's rich history. I want to thank the Rhode Island Historical Preservation and Heritage Commission and Kathy Abbass, Director of the Rhode Island Marine Archaeology Project, for organizing today's event. Kathy has been instrumental in some of the most significant historic shipwreck preservation efforts in our state and region. At the request of the archaeologist at the Rhode Island Historical Preservation and Heritage Commission, Kathy founded the Rhode Island Marine Archaeology Project. which continues to lead important historical preservation projects around the state. Thank you, Kathy. In 1999, while I was Attorney General of Rhode Island, I received word from the state's Historical Preservation and Heritage Commission that the Revolutionary War-era vessel, the Lord Sandwich, formerly known as HMS Endeavour, was believed to be at the bottom of Narragansett Bay. It is one of 3 historic vessels scuttled by the British during the Revolutionary War, just north of where the Pell Bridge now stands. To protect the northward advance to Newport Harbor against the advancing French fleet during the siege of Newport. As Attorney General of Rhode Island, I am symbolically arrested the Endeavour and the other vessels under Admiralty law and maritime jurisdiction. You don't often get to arrest sunken vessels, but that's how Admiralty works. That states the state property rights to the vessels to prevent salvage hunters and recreational divers from vandalizing them. The shipwrecks are now the property of the state of Rhode Island, and the Rhode Island Historical Commission is their rightful substitute guardian. Preserving this important archaeological site and preventing interference and pilfering of the vessels was an important step taken to prevent very promising historical clues. I'm hopeful it may unlock what may be one of the biggest archaeological finds in Rhode Island history. There are plans to begin pulling up wreckage soon, and I can't wait to see what turns up. This innovative work is helping us connect to our past and bring history to life. We are grateful to the dedicated archaeologists, historians, volunteers, and supporters involved in this exciting effort.
The origin for Rye Map sponsorship of the panel discussion this evening was the apparent conflict between private property owners and those who see a greater good in preservation. Our purpose is to air some of the grievances on both sides of that debate and to determine if any common ground can be identified. In the case of shipwrecks, this conflict usually engages salvers and archaeologists. But please note that in this discussion, we are not including those who are illegally removing materials from shipwrecks for personal gain or amusement. A salvager is one who has taken the proper legal steps either by contract with the ship owner or by specific court action to save the ship and or its cargo and to return them to the stream of commerce. Stream of commerce is the key because a salvager does this for the owner of the vessel and is paid for the effort. And sometimes, like in the instance of the Lusitania, the salvager may also secure the ownership rights as well. Tonight, we are not addressing the commercial efforts related to modern ship losses that are supported by insurance claims, but we are reminded that the salvage of historic shipwrecks must have a financial benefit because a salvager is also in business. So it is clear that the profit motive is the main economic goal for the salvagers of historic shipwrecks. We are not debating tonight what defines a ship as historic or who makes that decision. Those are issues for another time. But it is clear that the salvage efforts are driven by the need for speed to retrieve objects that are commercially desirable, and that the salvage process is often attended by the destruction of what is not of financial value. Unfortunately, salvagers sometimes shroud the description of their efforts in language that makes it sound like their artifact retrievals were properly done by archaeological standards, and this can confuse the general public, like the widow. Even if that were not the case, only 1 in 20 projects make enough from the sale of artifacts to defray the expenses of mounting the expedition. That means, despite a few high-profile exceptions, the salvage of historic shipwrecks is a very uncertain business. On the other hand, we archaeologists present altruistic motives for doing our work. That the study of tangible archaeological sites and their interpretation may answer questions that written histories don't address, especially for non-literate peoples and for social groups that are underrepresented in historical documents. We have special ethical constraints related to human remains, First Nation rights, and other culturally sensitive areas. We know that archaeology, like salvage, is a destructive process, so we don't dig unless there is a very good reason to do so. And we are bound to keep artifact collections together for future study, so their dispersal, as in salvage, is not allowed. Like salvagers, archaeologists must take proper legal steps to gain access to an historic shipwreck, and this means securing a proper permit. The debate of who has the authority to grant permits and how that authority is achieved is important. But beyond these short comments, my main point is that archaeology, for all our claims of motives for the public good, has an economic driver too. In the U.S., some archaeologists teach at institutions of higher education. Some archaeologists get jobs in state and federal agencies that mainly oversee the work of others. And some archaeologists are hired by commercial cultural resource management companies. The 19th century throwback of a wealthy individual, newspaper, or museum that funds an expedition is very rare today, despite the recent publicity surrounding Paul Allen's success in finding the Indianapolis and the Lexington. Instead, most archaeology today is financially supported by government funding. In the case of universities without large private endowments, this is in the form of annual budgets allocated by specific state governments to support the school's faculties and infrastructures. Although students pay tuition and may provide a bit of unpaid or underpaid labor, government-generated grants pay the hard costs of the university's archaeological research, including overhead to pay the institution for providing space, utilities, and support staff. In the past generation, many universities jumped on the marine archaeology bandwagon by creating academic programs to attract students who think the field is exciting. And some institutions did that without due diligence about the costs and benefits of such a program. Unfortunately, like its research, archaeology training is also expensive, especially in the marine field, and the chance for a graduate to gain permanent employment is limited. As a result, some schools are now reallocating archaeological resources to other academic programs. Archaeologists who work for state and federal agencies are tasked mainly with administrative oversight and enforcement of relevant laws and regulations, and most have little time to do archaeological research. Their jobs were mainly created by government mandate to manage government paperwork, and of course their salaries are paid through government budgets. It appears that neither universities nor government archaeologists generate the income necessary to defray all of the expenses of the jobs they do. On the other hand, commercial resource management firms are more similar to salvagers in that they are in private business and must at least cover their costs, if not make a profit. Many of these archaeologists are embedded in large engineering firms, but they too rely on the current preservation laws that require private or governmental property owners to pay for archaeological surveys and remediation prior to development. The development timeline often means that the archaeological work is rushed, and we call that salvage archaeology. In any case, it is not likely that such surveys and remediation would take place in government if government requirements were removed, and therefore cultural resource management companies would have no reason to hire archaeologists and would probably be out of business. A few small not-for-profit organizations, such as Bateau Below in New York and the Rhode Island Marine Archaeology Project, our own Rye Map, conduct good research. Like academic, governmental, and commercial archaeologists, we also have to secure permits and comply with all regulations. Unfortunately, Bateau Below closed down after 20 years of important work, including the Lake George land tortoise Rad-O study, a shipwreck that is now listed as a National Historic Landmark. However, Rye Map is still active and we have been successful in grantsmanship, but our main funding comes from memberships, class fees, donations, and especially the in-kind help of energetic volunteers. Now our goal is to develop an artifact management facility to serve all archaeologists in the Northeast and to create a public outreach venue to share the exciting stories of our local maritime history, both of which can be income generating. So although such small non-governmental organizations make their contribution to the profession of archaeology, they too must watch the bottom line. A savvy observer might draw the conclusion that modern American archaeology depends on the politics that created the federal and state preservation laws. Marine archaeology especially relies on the U.S. Abandoned Shipwrecks Act of 1987 and the UNESCO Convention and Law of the Sea address international issues. However, as public sentiment changes, these laws and regulations can change too, as evidenced by how the current U.S. administration has used executive orders to gut many federal agencies tasked with public protection. Whether you think that is a good or a bad thing is not the issue. The point I make tonight is that most archaeology done in the U.S. is at risk because its financial underpinnings are based on government regulations and government funding, and both of those are mutable. Therefore, not only should archaeologists pay attention to the current winds of political and economic change, but we should also take another look at how we might change ourselves. We need to stop hiding behind the altruism related to preservation and investigate ways that we can fund our work without the crippling dependence on government subsidies and without damage to our ethical foundations. Salvagers also need to take a realistic look at their business model too. Since only 5% of historic shipwreck salvage projects are financially successful, since all historic shipwrecks are non-renewable resources, and since a very limited number of them have the potential to provide economic gain to a salvager, then that's not a good investment. Therefore, I say a pox on both your houses for continuing the adversarial relationship between salvagers and archaeologists. It's time that archaeology learned the hard lesson of standing on its own financial feet and stop relying on the uncertain largesse of the government. And it's time that salvagers learned that historic preservation can be a robust economic engine too. So, can we talk? There may be ways we can work together for mutual benefit, find the funding we both need, and protect our shared human heritage. Only then will both sides succeed. Thank you for coming.